All right, well, hi everybody. My name is Pablo Arredondo. I'm a fellow at the Stanford Center for Legal Informatics and a member of a small legal research startup company called CaseText. I'm here with Professor Leiter to present really what was his brainchild. In fact, he said it was very important that his head be much bigger than mine. I said, well, the way to do that is to use Skype, so fake a hand injury, and then we can make it happen. I will be working the slides. Professor Leiter, take it from here and let me know when you'd like the slideshows to begin.
Okie doke. Yeah, first of all, I apologize for not being there, and then thank you all for coming. Also, and then I should just explain. I'll be having my hand will be up, and that's because I had a close encounter with an exhaust fan. As I was getting ready to come out here and ended up with several stitches in my index finger, and I have cuts on each one of the other fingers of my hand. So it feels better if I hold it up. So that's why I'm doing it. I'm not showing off. But I do appreciate any sympathy. So anyway, again, thanks for coming. Today, what we wanted to do is present. Oh, and I guess you could put up the first slide.
All right.
This is also very last minute, so if it's not professional, we apologize in advance. We're doing the best we can. But what we wanted to talk about today is something that we call the leading cases filter. This is a concept that an idea that I had several years ago, and without mixing too many metaphors, put a lot of blood, sweat, and tears into thinking about it and trying to get this concept to work. And essentially, what the leading cases filter is a tool, a way that online full-text case researchers can use to sift through the enormous volumes of case law in order to find the ones that are the most useful. We call them the leading cases, and I'll explain a little bit about how we've identified cases as leading cases and how the process works. I just want to give you a little background just to set up what the idea is. We'll quickly run through that, and then Pablo has actually done a lion's share of the work to prove or to show how this actually does work in practice. Essentially, somebody who teaches legal research knows the idea is to help the students use tools to find the best cases available. And the big challenge is the fact that there are just too many cases. Does anybody out there know how many cases are available on Westlaw? Okay, somebody from Westlaw told me that there are 12 million cases on Westlaw. Now that's a lot of cases. And the problem is how do you find the few cases that you want in order to do research in that, in any area of the law, to narrow it down. So initially, the way our common law case, common law system began with reporting of cases, they were published originally in nominative reporters. And the nominatives were typically topical case reporters. So a researcher interested in evidence law would go to the reporter, Jones' evidence cases or Smith's commercial cases or something like that. The idea was the reporter of decisions selected the cases to include in his report. And some initial research that I did showed that they were highly selective. And in many cases, the cases that the reporters chose to report were heavily annotated and heavily edited. And so what you have in Jones' evidence cases were essentially the leading cases or the important cases of the day. And that's where our common law system really developed in that climate, when you would go to a reporter and you knew that the reported cases were all good ones. Now, just as a little illustration of where we're at and what gave rise to the thinking or the idea that I want to present, I ran across this page, and I know that this is very bad PowerPoint etiquette to have densely textual slides. Oh, did you? Okay, now we're going to advance to the next slide, one with the 2 pages.
The dense text. Yep, we're there.
Yeah, there. So from in Kent's commentaries in Volume 1, buried way back there, I found these pages. I'm just going to read this to you. I know that this is not good practice to read a lot in a presentation like this, but these are just too priceless. And the highlighted portions there, Kent bemoans the explosion of case law. And it says, but to attain a competent knowledge of common law in all its branches has now become a very serious undertaking, and it requires steady and lasting perseverance. In consequence of the number of books which beset and encumber the path of the student, the grievance is constantly growing worse, for the number of periodical law reports and treatises which issue from the English and American press is continually increasing. I mean, that sounds dramatic, you know. And in those days, the way that you studied the law was to read the cases. And if you look down at the footnote and add up the number of volumes, it's about 800 volumes is what he's complaining about. So it's this grievous explosion of case law that is a big obstacle to the lawyers of the day, amounts to less than 1,000 volumes. Can you imagine what Kent must think of our libraries today with 12 million reported cases? On the next page, he makes this comment. Bacon speaks of the necessity of a revision and digest of the law in order to restore it to a sound and profitable state whenever there is risen a vast accumulation of volumes, throwing the system into confusion and uncertainty. The evils resulting from an indigestible heap of laws and legal authorities are great and manifest. They destroy the certainty of the law and promote litigation, delay, and subtle. So it just makes you scared, doesn't it? And that was the situation. Do anybody know when Kent's Commentaries was written? It was 1809. And now, some 200 years later, we have many more than books and cases that he was talking about. Essentially, what Kent was calling for was to remedy, and now we're on the next slide, the analog case reporting, was to remedy the situation that was, that eventually arose when West Publishing began to publish cases in later in the 19th century with analytical case reporting. And Kent was making these criticisms when case law was still being published quite selectively and with many annotations and things. And if he thought in those days that there needed to be a periodic revision of case law, the need even grew worse or more pronounced in the era when West Publishing Company began to treat cases essentially, or case opinions as commodities. West was, a brilliant company and a brilliant manufacturer, and he saw publishing more cases allowed him to sell more books, and so there was no incentive for him to publish fewer cases. And the problems that sort of gave rise to are twofold or severalfold. Here up on the slide, you can see some of the problems. First of all, he started publishing cases comprehensively, no selective case reporting. It was essentially up to the courts. Whatever they wanted to publish, they did. They were published chronologically. They weren't organized by subject. That was an obstacle to any case law researcher. And what everybody knows who has done any research in case law is many times the cases are repetitive or duplicative. And sometimes, even with the good cases, they're crappy cases published. So not all cases are, and not all opinions are equal. So the challenge of the researcher, of course, is to how do you, from this volume of case reporters, find the good ones? Well, in the 19th century and all the way through the 20th century, what we had to rely on were secondary tools. The West Digest key number system were helpful in finding cases in particular topics, coupled with Shepard's, helped you refine things and identify more popular cases. But what were probably the most important source for sifting through the volume and the growing volume of case law were the great treatises and law reviews and other secondary materials where experts in the law actually sifted through the volume of law and wrote about the good ones. So, next slide. What to do? Well, here we are in this situation where we've got 12 million cases published, and it's just exploding out of control. And there's a couple of examples of how case reporting is just run amok. You think about it, the Decennial Digest is now published in 3 parts. And it was odd enough that the Decennial Digest actually, for the last 10 years, included only 5 years worth of cases, now only 3 1/3. The advent of the Federal Appendix. And the explosion of case reporting has gotten out of control. Instead of fewer cases and more precise searching online, we now have too many cases. But all along, there was this body of secondary materials that was still criticizing the law, analyzing, and affirming what the courts were saying. There were 2 places. Courts, of course, would criticize cases themselves by overruling them and affirming them and so forth. And then scholars have continually been producing treatises and law review articles focusing on one case or another, or areas of cases of law, and analyzing them, and then highlighting the important cases in that particular area. So it always was a question of using 2 separate systems to find the good cases. Other sources, ALR and Shepard's were, of course, necessary to researchers to help us focus in as much as we can on case law. Now, one of the things, and I'm sure those of you who teach legal research or have done legal research yourself know very well, often it's you can use Lexis or Westlaw or any full text search engine and find good cases. And maybe in a particular area there are 10 or 15 key cases that you want to read, and 10 or 15 is about the limit of my attention span anyway. But the problem is you'll find those 10 or 15 cases in a search result that may include several hundred cases. And so you're still stuck with a method of sifting through your search results to get down to the good cases. Now, next slide. Towards, in the 1970s, when Lexis was, came out, Jerome Rubin's initial promises when he introduced Lexis was it was going to do two things. It was going to free everybody from the tyranny of the West Digests by bringing everybody up close and personal with the case law and the language of the courts itself. And the idea was, through this unmediated access to case law, you no longer would have to rely on the editors at West to show you which cases were on which topic, but you could just go right to the cases themselves, and it would be more productive, more understandable, more approachable to the researcher. Now, next slide. The unintended consequences that we've seen over the last 20 years, 30 years of Lexis and Westlaw are actually pretty extreme. It has created an explosion in the volume of cases reported through access to unreported decisions. But the most profound challenge was that once we had unfettered access to the cases themselves in the language of the courts, are the challenges of language and designing efficient searches to zero in on the important cases. It isn't actually as easy as it once seemed. And there are many classic examples that I'm sure most of you have heard of before, but things like the leading cases on landlord-tenant law in California never once used the word landlord-tenant law in the text of the opinions. I actually stumbled on a situation in Indiana where a line of leading cases on comparative negligence included a typo, and they spelled comparative incorrectly. And you can still search for comparative with an I instead of an A and find a line of cases that have misspelled comparative negligence. So if you're a good speller in Indiana, you wouldn't, you'd miss these cases. Other examples, the use of minors, infants, and John Doe in explaining or describing the capacity contract are also linguistic challenges, and there are many others. Blair and Marin did a famous report that showed that full-text database searching could only retrieve 30% of the relevant cases in a database. And part of this had to do with the vagaries of and imprecision of language, even though we think that it's very precise. So in response to these challenges of full-text case reporting. And now to go to the next slide, what Chancellor Kent was really calling for initially was something that we really need to keep in mind today. He was saying that all cases aren't equal, and some of them get to be confusing. And what he was calling for was a routine culling of the case law to get rid of the crappy cases and the unimportant cases, the inarticulate cases, and then just publish the leading ones to help scholars find out what the law is without getting confused by all of these confusing cases, duplicative or incorrect cases, as I said. One of the ways that this has been being done for all these years is through the great treatises and through law reviews. And if you go back and look at some of the really profound developments in law, in our legal system, the development of negligence theory, the sort of nuances of whistleblower law and things like that. These topics have been hashed out by scholars in law reviews many times and in treatises that they would write. One of my favorites treatises is Wright Miller, Federal Practice and Procedure, because it's such a massive and such an authoritative book. And I had the privilege early in my career working with Charles Allen Wright and seeing how, and talking to him, how he put his portion of the treatise together. It was really a very thoughtful discourse on what the law of federal practice and procedure was. They would actually sift through the cases, evaluate what the law was, write about it, and then cite just or only to the cases that they felt were instructive and that were leading cases in that area. And some years ago, I did a study, and I compared full text searching on a particular topic with a subject that was covered in the chapter of Wright and Miller, and compared the cases, and found that Wright and Miller's list of cases, the ones that they cited, was much more efficient than the cases that were retrieved through Lexis or Westlaw, the online services that were available at the time. Now, I'll probably be stating things that many of you already know. So the next slide, the leading cases filter. What my idea was, originally, it occurred to me once when I was teaching advanced legal research that if there was a way of connecting the two worlds, the world of secondary literature and the case reporters, you might be able to come up with a clever way of identifying the leading cases from among the massive body of case reporters. And essentially, it's a pretty simple idea. If we can go through law reviews or treatises, and then identify which cases are cited in the law reviews and in the treatises, and then that would then end up with a body of case law that are leading cases. In their leading cases, I called them that because scholars have identified them as the important cases in that area of the law. And so the trick is, how do we identify which cases are cited in the secondary materials, and then tag the cases or somehow apply them to the case reporter so we can do a search in a full text database, search engine, take your pick, any one of them. You look at your search results and then click a button and filter out the cases that have not been described by or cited by scholars. And then you would have filtering up to the top the cases that are generally recognized as leading cases. Initially, my thought was that perhaps only 10% of the cases that are reported, 10% of the 12 million, have ever been cited by scholars at all or in secondary materials. As Pablo will show you in a couple of minutes, our initial runs at this shows that the number may actually be considerably less, maybe just slightly over 5%, maybe 7% of the cases that are published are or can be identified as leading cases. The concept, or this concept of tagging cases as leading cases could also be applied to blogs, news sources, anywhere that experts are routinely criticizing and analyzing law. What that does is it gives the researcher the ability to go into a full text database, conduct a search, and then initially find the leading cases from among that list before then exploring the cases that may be on the periphery or may not be as important. So my last slide here, leveraging the scholarly community, essentially what the way I've characterized it as the leading cases filter is a simple way of sort of inside-out crowdsourcing. Without having the scholars actually contribute to creating the leading cases filters, we can go to their output, their scholarly output, identify the cases that they've already identified as leading cases, and apply them to a search engine, and filter out, like I said, the chaff and identify the wheat. Pablo and I were talking about it earlier this year, this concept, and he got very excited about it and has been working on collecting some data sets and has done some tests, and I was very excited at the result. And that is all that I have to say on the topic. Unless anybody has any questions, or I'll turn it over to Pablo and let him show you what he discovered.
Thank you, Richard. And we'll bring Richard back, obviously, for questions after the demo. Richard mentioned earlier something about am I doing the lion's share of the work. I think I'm more of the hyena who comes after the lions who've done all the work and finds this wonderful thing. I mean, the real heavy lifting, of course, were these law scholars who, over decades, have pulled these cases out. What I did, let me see if I can actually get out of here. Bear with me. Sorry. Okay, I need to escape from PowerPoint. Bear with me. Okay. All right. So what I did was actually quite simple. I basically wrote a small script that said, go through these documents, and if you see certain patterns, pull them out. The patterns that I chose were quite limited, actually. I did the US reporter, so if you had a number between 1 and 999, followed by capital U, period, S, period, and then another number. I did the same with the federal reporter, so F second, F third, and F. And then I did it with F sub. Immediately it might occur to you that there are some things that are going to be missed with that crude system. For instance, if a case has just come out, right, so you'll often get a number, a blank, 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 then US, and then number, 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 then blank, then US, then blank, 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 right? Because they don't know exactly what pages it's going to be on. And then you'll have a Supreme Court site, s.ct. If this is a particularly egregious omission on my part to not include those, given that one of the real weaknesses of a system like this, or blind spots, would be very recent cases, because law reviews take a time to come out, right? So if you're only pulling from law reviews, you're going to miss very recent cases. But as Richard alluded to, that's where blogs can come in, right? Blogs are the same day that a case comes out, you'll get it. So really, when looking at the system, you're going to see that blind spot. I'll start with my one that I did. I did patent litigation when I was practicing, so I'll start with that, but then I want to turn it over to you guys and you see what happens. So if you just do a type for patent, I've been demoralized by 70,000 result lists so many times. I mean, this is what happens if you just search for patent in our normal database. And I think that it's important to realize that for a lot of people, that number that you get back is sort of your first indication is if you've written the correct Boolean search, right? If you see a number like 70,000, you sort of think, maybe I need to change my search, right? And of course, every decision you make when you're writing a Boolean search, you're risking missing cases, and of course, you're risking false positive. But with the handy leading cases filter, the number becomes 280. So this is many orders of magnitude reduction, a much more sane number that appears. Here, this is sorted by relevance based on our keyword searching. If you do it by site count, you'll also see. Now, what's interesting here, when you do by site count, Miranda, that is not a patent case, right? And I think that one of the other things that I learned early on, and hopefully the ones underneath it will be, is that you have to look at the frequency distribution, right? So what will happen is, I extracted all these sites. Some of them appeared, hundreds of times, right? So your very famous cases. And then it sort of drops down like this. And then you have this long tail of cases that only appear once. They've been cited in one law review article. And truth be told, those are not often leading cases, right? They're not always. Of course, Miranda is a leading case in the subject that it is in. So now let's play with some other terms. Anyone volunteer a search query and let's see what happens when we filter down.
Second Amendment?
Second Amendment, okay, so let me put that in quotes. Okay, Second Amendment, 2,700 cases, if you just do it. Leading cases, 15. Now, what we haven't done, and what we need to do to fully validate this, of course, is go get the Second Amendment experts and have them come and verify, A, that we have precision, that these are all in fact leading cases, and then to assess our recall, did we get all the leading cases. But, just looking at, again, that difference between 2,700 and 15, it's the difference between being able to read them all and just feeling, demoralized, as many associates do, myself included. Let's try a couple more, and then I'll get into one variation on this that I've been, doing some.
Confrontation clause.
I'm sorry?
Confrontation clause.
Confrontation clause. I spelled confrontation with it, right? 8,500, 13. Voila, What's that?
Gross income.
Gross income, okay. Circa 14,000, 28. I demoed this at Stanford and someone said comic books as the thing. I'm like, man, that's not. 0 and 0.
How about vicarious liability?
Let's do vicarious liability. Isn't this so fun? I can just do this all day. Every term in Black's dictionary. 11,700 becomes 31. So you're filtering. I mean, we know that much. Something is getting filtered out, right? And we're still very early on in the process of looking at, what else we can do. But so far, I've eyeballed the patent cases, and it seems to work. Another thing I wanted to show you guys, and here you can tell we're switching from Richard's slides to mine because he won't let me name the filter after him, but I insist on it. Is that if you think about it, there's another thing that we can do here, which is to say, Westlaw and Lexis pay editors to classify opinions. This is an environmental law case, this is a maritime case, things like that. There would be some value in automating, or at least quasi-automating this process. And as it happens, the substantial number of law journals are actually topic-specific, right? I mean, we all think of the Law Review as the sort of the flagship one, but most journals out there, of the 900 or so that we looked at, concern a very specific area. So what I did is I said, okay, well, I'm going to say, first, I changed my script a little bit that said, first say, is the word environment in the title of this journal? If it is, and only if it is, then I want you to pull out the site, right? So I'm basically automating just pulling out from environmental law, and I did sports law, and I chose these because hopefully the title of the cases was going to indicate, what they were, so that we didn't have to go through the text of each one. And again, I did a frequency distribution to see, okay, how many times does it appear because you have that long tail. Oh, sorry, I realize I'm not in like slide mode here. Should I? Okay. So, right, so for environmental law, I found 57 journals with the title containing the word environment. And of course, the first time I brought this up with the environmental law professor, he said, well, what about the Berkeley Journal of Law and Ecology? And I'm like, oh, no. This is the danger of anything like this. Pulled out 7,300 unique federal citations from them, again, with my caveat that I ignored S.C. and US blanks. The frequency ranged from 1 to 233. So in other words, one of these cases appeared 233 times throughout these journals. And obviously a lot of them appeared once. Here are the big hitters. I know this slide is so ugly, but if you look at it, what you see there is the site, then the frequency counts in parentheses next to it. And if you sort of scan here, you start to see, there's a lot of Sierra clubs, a lot of shores, things like that, recycling. I know Chevron is definitely one of the big leading environmental cases. Interestingly, USV Lopez showed up, which is not, I believe, an environmental law case. It also showed up in the sports list that I'm about to show you. And in fact, if you look at a case that appears throughout all the different topics, the chances are that's going to be more about a civil procedure issue, right? Because it's something that's now relevant across topics. So you can actually isolate cases that are more procedural and not topic specific. And I know, see me if you want, or email me, I can give you guys the specifics and we can get into all this stuff. But generally, you start to see sports cases, including all the way down to ones that only appeared 12 times. This stupid Harvard guest thing is the bane of my existence right now, because every time I try to move it, it turns me off. Anyway, okay, so, and then sports law, 15 unique journals containing the word sport, 3,200 roughly unique citations that I pulled, frequency ranged from 1 to 78, and here they all come, right? So all of these NFL and sports cases, and you can see the distribution. Now, what I did like here, this one, Mississippi University for Women versus Hogan, that is a Title IX case about nursing, nursing students. And I think one of the things that's interesting is that cases can sometimes be relevant to your domain, even if the actual fact pattern is not, right? This type of filter will get that, right? If you just did a keyword search, or if you just relied on sort of an army of anonymous editors that maybe don't love what they're doing as much, you might miss that, right? So that's one of the advantages of a system like that. Relatively easy to implement. As I said, catches opinions that are relevant, but not on the facts. Disadvantages are you need areas of law that are prominent enough to get their own journal, right? You can't do this for satellite law, as much as I would like to. Also, the titles are sometimes, they match things together. So entertainment and sports law, right? IP law is going to cover copyright, patent, and trademark. So there's issues there. And then, of course, the lag time between when the case is published and when it appears. Oh, yeah, that's sorry. What that was just a very, sorry, bear with me. This heinous slide just tells you how many journal titles there were with specific words, just to give you a rough idea. So you only had 2 with religion, 16 with intellectual property, 97 have the word international in them. So, different topics are going to have different amounts to cull from. Let's get off of that slide as soon as humanly possible. Okay. Oh, that's the last slide, so I can't leave it. So if you want to see, we looked at the environmental law, we put up a very crude version of it onto case text. And just a word about case text. So case text is a community sourced, we say community instead of crowd because crowd scares lawyers. Crowds are very unruly, but a community, very nice. But in fact, it is crowdsourcing, right? Anyone can add content, anyone can add meta tags. And what it gives us is actually the nimbleness to take an idea like Richard's and to really implement it quickly, which is cool. So here, 134,000 cases have the word water. Only 4,300 of them got tagged environmental law, meaning that they showed up in at least one of the environmental law journals. And now you can combine that with the leading cases and you're down to 149, right? So you can put these on top of each other to create more nuanced filters.
Are you saying that people can add cases and then you're running the filter on them, or how does that process work? So
people can add on case text any tags they want directly to opinions. for something with batch tagging like that, right now you have to go through us, right? We want to set up a system where people can propose, and basically you choose whose tags you want. So, you know, a guru at MIT comes up with a brilliant tag, everyone can use it. If somebody who you don't want to use their tags, you don't have to, right? But that's something we need to set up.
So individuals can add leading cases tags?
Technically, you can, my friend. Use that power well. Yes, you can. And you can be, you know, downvoted if well, you know, there's voting systems and things like that. You can be called out, but yes.
So I think this is an amazing tool, and I don't know enough about case text to know this, but is this something you would consider open sourcing? Your code for this?
So the analysis, any analysis added to it by any of the community members is public domain under a Creative Commons license. At this point, we haven't put out all the code, right, our internal code yet. I know there are open source annotation projects out there as well. You know, we're a startup too, so there's that aspect of things. VCs and open source don't always go together as well as you would like. But certainly, the whole point of Case Text is to create a free, if not alternative to Westlaw and Lexis, certainly something to supplement Westlaw and Lexis. And we'll be, you know, when Richard talked about, you know, this is crowdsourcing without the people knowing that they were doing crowdsourcing, right? Really, when you think about it, these authors did not mean to create this filter, they just did. We're doing that with a whole number of systems, right? So law firms send client emails, hey, this new case came out, we're so on top of it, look at our summary. We've harvested all of those with the blessing of JD Supra. And so now you have that analysis appended to cases directly, right? Other examples, you know, when a court will say in an opinion, John versus Doe, holding that, X, Y, 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 you know, they give those really concise holding parentheticals. We're pulling all of those out and attaching them to the cases so that you get that.
So short of open sourcing the code, does Case Text have an API? So I work for OYA, which does so much Supreme Court cases, and I'd love to be able to say, you know, these are the leading cases. You know,
first of all, much respect to OYA. Love you guys. Yes, we're building an API. And absolutely. And in terms of the leading cases filter, that was an academic project done with Richard. I can give you that. I'm happy to share that data with you. That's cool. There's no ownership of that. Please.
Have you thought about adding the treatises, or just searching them? Is it too?
That certainly would be in the vein of what we're doing.
Yeah.
I didn't add the treatises. It's just a matter of how I could get a hold of things, right? So I couldn't. But certainly that would be good. I would be curious to see how many does it add over the law review article, and does it miss any that they get. But that would be another natural sort.
Yeah, and I should say that initially I thought the best source for leading case tags would be treatises. But if you think about the logistics of going through some of the treatises to identify the cases that are cited, they're extremely difficult. They're just too big and very proprietary. And it wasn't until just the last couple of years that they've been available online in format that you could play around with it.
Any other questions? Please.
Just thinking, just as all cases are not equal, a lot of all secondary sources are not equal either.
That's right, and this is something we thought about, but if you think about it here, it's not, we're just talking about the selection process, right? It's not that we're looking at the analysis that the author provides of a case. So unless you have a journal that's so bad that the guy's just like, I'm going to just grab a random handful of cases and throw it in there and call it an article, right? And for all I know, there is a journal like that out there. It's unlikely, right? So the sort of elitism, if you will, or the ranking of the journal really doesn't come into play. Especially because think about you're carving off, out of 40,000 cases, you have 200 left. If one gets in that's a little bit, maybe the guy shouldn't have included it, that's not as big a threat. So you're right that they're not all created equal. It doesn't really affect how we would go about this filter. Please.
And then there are also further refinements that we've talked about, things that you could add to the leading cases filter to make it even more, I'm not sure what the right word is, more analytical perhaps, but it would be possible to rank the quality of the citations. Which journals they're cited in, who the authors are, have the authors that are citing them written more than one article, have also written a treatise, the seniority of the author, and things like that. That would take a little bit more work, but But these are, refinements that add to make it even more, more useful as far as filtering cases.
Please.
I was just wondering about participation and who you're seeing, what populations are adding tags, if you have any sense of that, because I'm a librarian at a large firm, and my lawyers probably could benefit greatly from this, but would be the least likely to have incentives to contribute to it.
Right. So we thought about this. So with the law firms, we think you guys are going to need your own separate law, your own common law to call your own, because you can't be like, hey, this great work product that I just did, I'm going to announce to the world, right? I mean, even small innocuous tags, if the other side can say, look what cases he's tagging, that's probably going to be in the brief. So we were sympathetic to the fact that the law firm community is not going to be sending out a lot of crowdsourced systems. We're going to build you your own system internally. In fact, that's what's going to pay for everyone to get the free one. That's really going to be awesome. You guys are going to pay. But you can imagine, these firms over the decades cultivating like their own little bonsai tree, their own law that turned into their thing. So yes, right now the tags are coming from a variety of sources and really good analysis from professors, some attorneys who've argued the case that are more sort of public facing. But stay tuned, and we'll find you guys soon. Please.
Have you found that this is limited to federal law, federal case law? You notice. Have you found that there's more of a uniformity of terminology with federal cases? I'm wondering, you put up, for example, a search for vicarious liability. Would that also pick up respondeat superior?
So interesting. If people are using tags to then create those sort of synonyms, yes. In fact, that's one of the advantages that you can have about it. I should know that case text now has California and Delaware law as well. So case text is not limited to federal cases. Our prototype of the filter certainly is. But that's a great point. I mean, one of the hardest areas is synonyms, right? How do I know that this phrase means this phrase? And that's something that's also evolving as things happen. A system like this can actually evolve very quickly, right, without having to have a whole institution change its policies. Please.
And do you have any solutions for the small states that, don't have a lot of well-reviewed articles written about their case law?
Blogs. You're saying small areas of law that don't have a lot.
Well, you mentioned California and Delaware. It sounds like you're moving to state law also.
Sorry, small states, not small topics of law. No. Although blogs would be the place that I would naturally look. Hopefully there's no state so small that nobody will blog about it. And then, would be, again, that same selection process.
Or no lawyer would blog about it.
Right, that's true. That's true.
Yes.
Please.
So I'm kind of curious as to whether you've done any sort of, sanity checks to look at how well your results by looking at secondary links to cases line up with primary links to cases, so citations within the cases.
Right.
Do you see any disconnect? Do you see like certain cases are cited more by secondary sources than by other cases?
So you're absolutely right to ask that question. The use of the filter is, in a sense, only how much do we learn and get that we don't get from just sorting by citation count. And no, I have not done a thorough analysis on that, although I just got, they just put me out the cite counts for all of these guys. But you will also notice that citation counts, certain areas of law have less citation counts just generally because they're about religion, right, and not about guns or something like that, right? Or so there, the citation count could be, it could obfuscate what are in fact leading cases. But that right now is just me thinking in the abstract about it. You're right, and everyone deserves some actual numbers on that, and that will be hopefully forthcoming. But it's a great point.
Pablo and I intend to write this up in the near future, and that's one of the precise questions that we want to look at closely is compare the citation counts using, Shepard's or other kind, traditional tools, and see how it compares to the citations, in secondary material.
And by publishing about it, we add more citations to the data set. Actually, that can be monitored by increasing the overall efficacy of the filter. It's very meta. Please, go ahead.
My biggest question with this is that it's great you put water, but who's going to just look for water? You're going to have water with other stuff, and when you have your search, you might come up with 12 cases with your search. You're not going to then get a leading case of what? One?
So that's interesting. Let's try it. Water plus.
I don't know fluoride. I'm just saying.
Well, fluoride, that's pretty specific. But
you're not going to want to search just the word water or Second Amendment.
Right.
You're not going to do that.
Right. I mean, that's true. Although, I mean, if I do something like, so this is one that's near and dear to my heart, is patent obviousness, right? Because obviousness is a specific section. There you'll see 5,400 turning into 59, right? I think even, I agree, at a certain point when you got enough Booleans, then you do start to, what's the point, right? You've already narrowed down. But remember, with each of those choices you're making, you're running the risk of missing a case because of the random word you chose, right? So you choose biotechnology because you want to narrow down to biotechnology. Unfortunately, the case says DNA 7,500 times, but not biotechnology, and now you've missed it, right? If that makes sense. But you're right, at a certain level of zoning in, it becomes irrelevant.
I just have a question. I tried to run a particular search and wondered what the explanation was for this. I typed in prejudicial publicity. The first case I get is Shepard versus Maxwell, which is what I would expect to get. But then I click on leading cases, and Shepard versus Maxwell goes away. Why? I mean, I guess I could go in and do the crowdsourcing and say it's a leading case.
No, but this is an example of it failing.
Okay.
I mean, clearly, right? I don't know what to say except for whatever reason that was not picked up in our system. And it seems like it is a leading case that it would have been there, right?
Okay.
So that's something to note.
Okay.
Again, this is a rougher prototype, but that does concern me, actually.
Okay.
This is where you use that power.
Right. Right. Everyone does their own little niche. We'll have this thing in great shape in no time.
Yeah, so do search terms include statutory provisions or even West Digest?
Certainly not West Digest members. You mean like 35 USC?
Yeah.
Yeah, so we can do that, I think. 35. So it actually gets the statute, and then in cases comes to 299 from, without it, 49,000. Although that, no, that's not right, because we're not in quotes here. We're a young engine in terms of our search, so we're still going. That's where there are no leading cases for this one. Oh no, there it is. Wow. But I would want to see John Graham versus Deere there at least, so it's trouble. Any other questions, please?
So I'm curious as to whether you thought of looking at like clustering as a way to potentially improve searching for cases. So for example, if I were to query for something like Second Amendment, and I'd get a bunch of leading cases that were cited by a bunch of journals, if your data would be able to suggest for another case that was appeared in similar articles as this case that I'm particularly interested in,
Right.
but didn't appear because of my query.
Yeah, I mean, clustering is just a great thing generally to do that. And I think actually one of the areas, this is a completely separate area, but I'm looking at is string cites. So you have two cases that don't cite each other, but some judge saw fit to be like, I'm going to include them in the string cite together. So they're sort of cousins, if you will, right? I've been doing some experiments with that and seeing good stuff. My favorite thing to test when you want to see clustering is do DNA and then cluster it, because you have all of the guys who are like, you can't search my DNA officer, right? That's one whole area. And then you have all the people fighting over the patents over DNA. So you really get those two distinct little clusters. They're very emphatic. But yeah, that's something that's good for everybody.
Have you thought about putting like a visualization in front of this so you could see all the clusters?
Like a Ravel kind of game? Yeah, I don't know. Yeah. I mean, Ed Walters did it. That's out there. That's there, and it's beautiful. Actually, I think we would like to see how the secondary sources stuff looks through the Ravel lens. I usually introduced Richard to those guys because I think that would be cool. Cool. Please.
So I'm just sort of thinking out loud, but I'm wondering if you get some sort of time discrimination going on, because the explosion of topical law reviews is relatively recent as in our case law. And a lot of people, when they write law review articles, are writing about new cases. Have you been able to tell whether that actually has an impact, or am I just making something up? Or
No, you're not making anything up at all. That's a real concern. First, in missing new cases because of that lag time before law review was put out. We actually, this data was only looking back 20 years for law review articles. So we did not, whatever effect that had, and I'm sure it did have an effect, that was limited. So my sense is that is within the explosion of the topical journals as well. But yeah.
And I didn't hear the question. I'm having a hard time hearing participants, but I think that you raised an interesting question, or one that we've been talking about. Several years ago, not too many years ago, I did an analysis of citations to law review articles. What I was trying to prove is that online access to law review articles affected the age of the cases cited by modern scholarship. And what I found was that in modern law reviews, 70% of the articles cited by modern authors have been published within the last 15 years. Okay, and I thought that was attributable to the fact that at the time I did this research, law reviews weren't even available online, and that everybody was doing it online. Anyway, make a long story short, what we discovered is that apparently a typical historic pattern of scholarship. Modern any scholarship at any period of time always cites to, and it's about 70% of the material that they're citing to has been published within about the last 10 or 15 years. So scholars are always re-sifting new cases. So now there are those 30% of the cases that are older than that fall outside of that time frame, but they're maybe less important, but they're still significant. Ultimately, the leading cases filter, or any search engine like this would need to be more comprehensive to get those older ones, those 30%. But for the most part, working within the last 15 or 20 years, you're going to get the lion's share of the useful scholarship. Does that make sense?
They're not. Any further questions? All right, guys. Well, thank you so much for having us. And Richard, do you want to announce your email for folks if they want to follow up? I think you and I'm Pablo at casetext.com. It's probably the easiest one to remember. So feel free to. What is it? Pablo at casetext.com. You always have to start if you just get your first name. All right. All right. Signing off, Richard.
All right.
That's what I'm using my own Yeah. Because you came and talked to us.
Oh, yeah, that's right.
The actual case here on the yeah. Oh, yeah, I know. I'm going to pressure you, or I'm going to pressure
Yeah.
I'm not certain. Retired. She was the big free but there's still a lot of people. Let me contact them and feedback. I don't know exactly. Yeah. You say. So we have.
No, it's always good. You know what I said. That'd be great.
Well, yeah. So I'll put you here. Thank you for that.
Hey, guys.
I love this. Wow.
All right, good. Glad to hear it.
Yeah, find a way for us to get back to you at some point.
I love you guys.
Yeah, if you're ever doing something with arguments,
I think we are cool to have curated understanding. This was a great question. This situation answered it. Perfect. Second guess all those attorneys.
Yeah, that's perfect.
On Monday morning quarterbacking.
Exactly, that's awesome. So yeah, I don't know if you know this, but we're expanding the state Supreme Court too.
Excellent.
So we're doing California.
Fantastic.
So I know you mentioned California, so if you want to take a look.
I'd love to do that. No, and for us, the more stuff we can put up there and see what people want to answer.
Yeah, and I'd love to see the invitation.
Yeah, absolutely.
So, all right, yeah.